Good afternoon, and thank you for your participation in the Tennessee Human Rights Commission Fair Housing 101. I am Sabrina Hooper, the Deputy Director for the Commission. As Director, I am responsible for managing the agency's programs for employment and housing and public accommodation. I have been with the Commission since February 2012, and with me today is Richard Gadzekpo. Richard?
I'm the housing coordinator, and I'm responsible for the housing division when it comes to enforcement, and I've been with the agency since 2009.
Okay. We are both going to share and cover a lot of ground this afternoon. If you have questions, use the chat function. This is being monitored, and we will answer as many questions as possible at the end of the presentation or where appropriate. It's April 29, and we are at the end of the month. This month has been identified as Fair Housing Month, and it's a dedicated month for where all professionals come together and have events to recommit to the goal of eliminating housing discrimination and creating equal opportunity in every community. As you're probably aware, President Lyndon B. Johnson rallied Congress to sign the Federal Fair Housing Act of 1968, 7 days after the assassination of Dr. Martin Luther King. This Fair Housing Act had been a part of Congress for 3 times, and it wasn't until after Dr. Martin Luther King was assassinated that it was signed. So some background on who we are. We are the Tennessee Human Rights Commission. We're an independent state agency charged with enforcing the Tennessee Human Rights Act and the Tennessee Disability Act. Our mission is to safeguard all Tennesseans from discrimination through enforcement and education. We receive and investigate complaints of discrimination in employment, housing, and public accommodation, and we ensure that the state of Tennessee is in compliance with Title VI of the Civil Rights Act of 1964. So that is just a little bit about what we do. As part of our work, we also have partnerships with federal agencies, the U.S. Department of Housing and Urban Development, or HUD, and the U.S. Equal Employment Opportunity Commission, EEOC. And with both those partnerships, we are able to dual file our investigations if federal laws apply. And what this does, it allows for the elimination of duplication of efforts. If complaints are filed with HUD, but the violation occurred in Tennessee and it's jurisdictional for us, then HUD will refer that case for THRC to investigate. And likewise, if we receive a case and it's outside of our jurisdiction and federal laws apply, then we will refer that also to HUD. And so either one of us work together for us to cover all complaints of discrimination, and it's a great partnership. The same as with the EEOC, we're able to do that in employment cases. So let's get into a little bit of housing protected classes. From its inception, there was 4 protected classes. There was 4 protected classes that was brought into fruition. First was race, color, national origin, and then in 1974, sex was brought in. In 1988, familial status and disability status was brought in. So who was covered under the Fair Housing Act and why was it established? The Fair Housing Act was established to protect people from discrimination in renting, buying, and in lending and financial aspects. Anyone who is exercising or enjoying their rights under the Tennessee Human Rights Act or Fair Housing Act trying to secure housing is covered. Anyone who has encouraged others to exercise their right are also covered. So here's the seven protected classes right there. So some prohibited practices. It is prohibited for anyone to refuse to sell or rent a housing, refuse to negotiate for housing, or making housing otherwise unavailable simply based on the race, color, national origin, religion, sex, familial status, or disability. Some other specifics are, based on those protected classes, you cannot deny a dwelling, set different terms or conditions, provide housing services or facilities, provide different housing services or facilities, or falsely deny housing is available. For instance, if I'm driving by and I see a sign for a rent sign, and I call the person on the phone and I ask them, is the apartment available, and they tell me yes, but then shortly after I show up and they see that I am African American, and they decide to tell me that the housing is no longer available, that would be a case for me to be able to file a complaint. Also, it is illegal to threaten, coerce, or intimidate or otherwise interfere with anyone exercising their fair housing right or anyone others exercising their right. Even in advertising, you cannot make any statements that indicate limitations based on those particular classes. Again, I see a house for sale, I have a family, and I look at the advertisement and it says no children. That could be a potential discriminatory complaint in familial status. Now, there are some exemptions and there are some properties that are in exemptions, but it doesn't matter if you fall under an exemption, you are otherwise, you are still held accountable if it's discriminatory advertising or discriminatory statements. And we'll talk a little bit further about exemptions later. When you're talking about lending, you cannot refuse to make a mortgage loan, refuse to provide information regarding a loan, see somebody who you think is not able to understand the paperwork, or simply because you think that they don't deserve to have a point system, that you raise the point level or have extra fees in there to make the loan go through. You can't do that if it's based on those 7 protected classes, if that is the only reason. Refuse to purchase a loan. So all of those practices are prohibited under the law. Another part that's prohibited is called retaliation, or what we call retaliation. So if you are having any adverse action taken against you when you're trying to secure a home or aiding somebody else in securing a home, you are able to file a complaint with our agency, and then something happens because you filed a complaint, that would be considered retaliation. And so parts of protected activity that we call is if you're filing a complaint, you're assisting somebody with filing a complaint, or you've been called as a witness in an investigation. You've had visitors come to your house, and visitors of different race or religion or et cetera come to your house, and your landlord doesn't like that and they evict you for that, then that's part of protected activity. Or you've encouraged others to exercise their right under the fair housing laws. All of those would be considered protected activity, and retaliation could not be taken against you. We would definitely hear that case. So who is subject to that? Who is covered by these laws? So all of the covered markets would be in rental, sale, lending, insurances, anything that is associated with residential housing. Covered individuals, people that you might not think about is architects, engineers, landscapers, brokers. All of those people associated with providing housing could fall under our law and are subject to our laws. Now you say, okay, all those people, so what's the covered dwellings? Basically, if the basic understanding is where you live with an address, anything that has an address, all of those properties would be covered. One that you may not think about is when you say other residential housing would be extended stays. And there's a time limit on how long you stay in an extended stay that may become a residential for you. So we talked about that we were going to say there's some exemptions to the fair housing laws. So I'm going to read these specifically from the slide because they're very detailed and they're very specific. So any single family house that is sold or rented by an owner is exempt from the Tennessee Human Rights Act or the Fair Housing Act, provided that such an owner does not own more than 3 such single housings at one time. Such exceptions apply only to one sale in a 24-month period when the house is sold by a private individual owner not residing in the house at the time of the sale. Such house is sold or rented without the use of a broker, an agent, a salesperson, and without publication, posting, or mailing after notice of any advertisement. So these 4 things are the only way that a single family house sold or rented can be exempt from our state and federal law. So 3 or less at any given time, 1 sale within 2 years, and no use of a broker or salesperson, and 0 advertising. Here's a couple of more exemptions. If you own a 4-unit house or less, and you live in one, so I live in a duplex, I live on one side, I rent out the other side, I would not fall under the Tennessee Human Rights Act or the Fair Housing Act. If I have a sale or rental of buildings not operated for profit, so religious organizations are exempt from those. As long as they're renting, you have to have that religious organization, you're renting to people of that same religion. Private clubs that are not open to the public. Now this one gets a little tricky because some will say private clubs for members only, but then they rent out one of their areas to the public. At that point, they may not be exempt anymore. And then certain elderly housing. If it is specifically designed and operated to assist the elderly, is intended for and solely occupied by persons 62 or over, or intended and operated for occupancy by at least one person 55 and older in each dwelling. But remember, even if your property has fallen under one of these exemptions, it will come out of the exemption and the laws will apply if the complaint is that there was discriminatory advertising or discriminatory statements used. So that's kind of the parts of what Tennessee Human Rights covers, and that's what the laws are. And I'm going to turn it over to Richard Gadzekpo, and he's going to talk about specific THRC jurisdiction. Richard?
Thank you, Sabrina. And thank you for participating and staying until this point. Most often than not, people wonder why we do accept certain complaints because they look at the complaints on the face value and they tend to think it's frivolous, that we should not spend our time looking into that allegations. But by law, if certain jurisdictional elements are met, we have to accept the case on face value. And the basic jurisdictions are standing. That is, the complainant must make a claim that he or she is about or has been injured because of one of the protected classes. When somebody comes to us and they're alleging discrimination, the first thing we look at is, does this person have standing? Timeliness. By law, we have to and can only investigate cases that occurred within 180 days. So jokingly, I tell people that if it is after 180.5 days, we will not be able to accept it for investigation. Rather, we will forward it to our hard counterparts who are able to investigate such claims within 360 days. We also have to then establish jurisdiction over the respondents to ensure whether they are exempt or not. The subject matter also has to relate to the Fair Housing Act or the Tennessee Human Rights Act that is based on one of those protected classes. Now, as you will see on your next slide, we want to now look at the question of disability within the meaning of the Tennessee Human Rights Act and the Fair Housing Act. Within the meaning of the Act, a person with a disability must be substantially limited in a major activity, such as walking, talking, seeing, listening, hearing. And there are other situations that we look at on case-by-case basis. Also, a second situation should be or could be that a person has a record of such impairment or a history of such a disability. And then the third thing that we look at is that the person is regarded as having such an impairment. In other words, the person is believed to have a physical or mental disability. On the issue of disability, there are two key areas. One, namely, reasonable accommodations, and the second one being reasonable modifications. What is reasonable accommodation? I always say that reasonable accommodation has to do with an exception, a change of rules, policies, practices, or services of a housing provider. For example, I may come to you and say that because of my disability, I am requesting that you provide me with maybe a parking lot, or change your rules, or allow me to have a service animal. That is considered as reasonable accommodation. But the request must always relate or be related to the individual's disability. If it doesn't, then the request is not within the meaning of the Act, hence the housing provider can refuse it. There are some situations where a provider may refuse to grant the accommodation being requested, and it is only when it will impose an undue financial or administrative burden on the housing provider. So when somebody comes and says, I need a reasonable accommodation, it is not just maybe an outright situation where you will say that, well, because it is going to be unreasonable and impact on me negatively, I will not grant it. There is what we refer to as the mandate or the duty to negotiate. In other words, you need to enter into an interactive process with the complainant to seek an alternative means or ways by which the request can be, or the need can be met. Some examples of reasonable accommodation is, as you will see on your slide, somebody may come and ask for a reserved parking. A current issue that we've had, or 2 or 3 cases, has to do with rent. All these individuals are on social or are on disability, and they receive their checks sometimes after the 5th of the month. So they go to their landlord and request that, please, because I received my social security check on the 10th, allow me to pay my check, my rent on the 11th of every month after I've received my disability check. That is saying that please change your rules regarding due date for rent. So it's considered as reasonable accommodation. One key area that keeps coming and people fail to understand is the issue of service or support animals. And we'll talk a little bit about that sooner. Or maybe let me just go back. Let me talk a little bit about the service or support animal. As it relates to the service or support animal, sometimes people want to believe or think that the animal has to be trained to provide a service. But within the meaning of the law, any animal that is individually trained to do or perform tasks for the benefit of a person may be considered as a service animal. However, there is also emotional support animals. The emotional support animals, it's any animal whose presence could, I'll use the word, mitigate the emotional or psychological symptoms of an individual with a disability. And regarding the support animal, the animal does not need to be trained to perform a disability specific task. All that is required is that the animal helps mitigate the situation. There is no legal requirement for service animals to wear visible identifications, have documentation, certifications, so long as, example, for it is serving the need of the person with a disability. Sometimes at first sight it might not be visible or obvious that the animal is providing any service. However, if a physician supports that for a person with a disability, then the request needs to be granted. On the issue of reasonable modification, it is clearly related to the issue of adjusting or changing the physical appearance of a structure. It has to do with the structural change made to existing premises. And these modifications are done at the expense of the person with a disability. However, if the landlord is a recipient of federal funding, then reasonable modifications may be required. The respondent or the owner of the property will have to bear the cost, unlike reasonable accommodations. Some examples of reasonable modifications is, as you see on your slide, installing of ramps or curbs, installation of grab bars, widening doors, and lowering of cabinets. So that is what we have concerning, or I want to draw your attention to when it comes to reasonable accommodations and modifications. On the issue of familial status, another aspect of the law has to do with familial status. And in terms of familial status, the law deals with it in terms of people with children under the age of 18 or at 18. In other words, you may not discriminate against families in which one or more children are under the age of 18. If a parent has a child within this age bracket, or a person who has legal custody, designing of a parent, and much more so also a pregnant woman, we cannot discriminate or cannot be discriminated against because they are pregnant. The Act prohibits that. What has been sometimes the situation is people do have good intentions. They might want to say that certain portions of the unit, children cannot go to that side of the property. That can be construed as discrimination on the basis of familial status. So at this point, I will want to give you some scenarios that has to do or relates with what we've been talking about so far. And the first scenario is a situation where, in checking references on an application for a vacant apartment, the owner learns that an applicant does not have the best housekeeping habits. He does not always keep this tenant, or incoming tenant does not always keep his or her apartment neat, and the owner does not want to rent to such a person. Could this be considered discriminatory? Think about it for a moment. And this is where you will have to be honest with yourself and give yourself the score whether you pass the scenario test or not. In response, it is not discriminatory because it's not a protected class. However, if the person has a disability and it is known to the person who is going to rent the units to this individual, then it might be lawful, because it is because of the person's disability which causes him or her not to be able to keep the house clean as it needs to. Another scenario is an apartment complex that has a no pet policy. And in the no pet policy, sorry with my cursor, but with the no pet policy, because of the no pet policy, the owner denies a request for the tenants to allow or to have a pet. The question is, could this be considered discriminatory? And your guess is as good as mine. If the owner says no, he or she will be discriminating on the basis of the person's disability. Another issue that is related to pets is that it is illegal to require the person with a disability to pay any fee or charge a fee for having a service animal or a companion animal. However, the person will be responsible for any damages that is caused by the animal. The person will also have to be responsible enough to clean after the animal and make sure that other laws pertaining to pets is being observed or obeyed. A third scenario is that an apartment complex does not assign parking spaces, but a person with a mobility asks for a reserved space near her building. However, the landlord refused, stating that it will cause them difficulties with others who had requested assigned spaces. Will this be lawful or illegal? An apartment complex will not have, which does not have an assigned parking, will have to find ways and means to grant that request. A case in point that we investigated, the ownership's excuse was that they do not have enough parking spaces, and they outrightly denied the request, and they did place individuals on a waiting list. The law forbids that. We had to work with them to come up with a ratio that was acceptable. Because the key element of the law is that reasonable accommodation or modification is to afford the person with disability to enjoy the unit just as any person with ability will be able to do. So at this point, we will pause for your questions. Any questions?
I believe we have someone monitoring that for us, so we'll wait to give you a couple of minutes to see if you have questions. Just go ahead and type those in the text box at the bottom on your webinar.
Doesn't appear that we have received any questions.
Are there any events coming up, Susanna, that you would like to give?
Sure. If you're in the Nashville area, we have our annual employment law seminar coming up on June the 12th. You can find that information on our website, tn.gov/human rights. So if Richard can click through to the next slide, can show our contact information there. And we do also have in the Nashville area, we have our hearing on the status of human rights coming up on May the 12th. That's going to be at the downtown Nashville Library. Again, you can find that information on our website. And we are on Facebook, so you can connect with us that way. Also, we are recording this webinar, and it will be hosted on our YouTube account as well, which is youtube.com/Tennessee Human Rights. And that's all we have coming up right now.
Great. Well, we still have some participants on the line. If you have any questions, just go ahead and type those in. We'll wait here for a few more minutes. Well, great. Well, thank you all for participating in our Fair Housing Seminar 101, and we look forward to presenting you with more of these in the future. Thank you and have a good afternoon.
Thank you.